Pete Rogers. Pete, and we're talking about estate planning, the basics. Pete has practiced family law in Colorado since 1970.
What?
A significant portion of his practice is preparation of wills and powers of attorney, as well as counseling and representing persons opening and administering estates for deceased Colorado residents. Thank you for being here today, Pete.
You're welcome. So, I recently I've been practicing law for over 50 years. Thankful for the good health so I can keep on going. One of my good friends died about 8 months ago and named me his personal representative. So I've had the personal experience going through some of the things that we talked to you about. Okay? So the main thing I want you to get is don't worry about probate in Colorado. Please.
Oh.
First of all, there's a federal tax exemption. So taxes, don't worry about it unless you got more than $12 million. Individual exemption is $12 million. Couple, 24.
Thank you.
So, man, I don't have to worry about it, and probably most of you all do.
So does that, I mean, it seems to me that there should be kind of like estate size requirements for forming a trust. I mean, because isn't it not really worth it if you don't have $12 million or $5 million?
Oh, there are reasons.
Okay.
There are reasons. We're doing the basics here. I have a disabled daughter, so it makes sense for me to have a trust
For her, right.
Okay? And there are other reasons, okay? But generally, you don't need it unless you got $1 billion. Okay? There are good reasons to do it, but I think that's kind of beyond basics. Okay. So look, you all own your property. You may have gotten stuff from your folks that's important. Okay? You have the right in Colorado, anywhere actually, to leave that property the way you wish it to. Okay? You can leave it to your children, your best friend John, your high school buddy, you want to have your library, all of it. The one person you can't cut out of your will is your spouse. In Colorado, the spouse has a right to elect to take against the will. For example, your will says, I leave everything to my friend Pete, and my spouse gets nothing. The spouse can come into court and say, whoa, 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 wait a minute. I'm a spouse, I choose to take against that will. Okay. And that spouse will get it, up to 50%. Okay, so here we go. Get rid of that little thing that shows up. What's the next? Yeah, so the reason you need a will, besides passing the stuff you want, great-grandma's hutch, whatever, okay? If you don't have a will, the state of Colorado writes one for you. Mm-hmm. And that the way it's written in Colorado is, it's called a parentella system. It goes by blood. So, I've got 3 children. One of them dies, and let's say my will says I leave it to all 3. One of those children dies, but they have I have grandchildren. If I don't have a will, the one who has deceased, their share goes to the grandchildren. Okay? In a will, it doesn't have to be that way. You can write the will any way you want it. Okay? Like I leave it just to the children who are alive on my death. All right. Is it possible in Colorado you can write your own will? It's called a holographic will. Do it in your handwriting, not on the computer. Do it in your handwriting, sign it and date it. It is legal in Colorado. Story. My dad asked me the same question. Can I do that? Yeah, Dad, it's got to be in your handwriting, date it and sign it. What did my dad do? Not valid unless it's signed front of two witnesses. Good news is, me and my brother and my sister knew exactly what needed to happen, so no problem. But it's gotta be in your handwriting. If you do,
Even if it's illegible.
yeah. I've only recommended once to a client that they do a handwritten will. That was in an emergency situation. But don't do it, okay? So what happens? Talk to your lawyer, and then you write the will. It's typed up, two witnesses. Two witnesses. A witness can be a beneficiary. Husband and wife come in and they sign wills. They can each witness the others. And then the lawyer's secretary is the other witness. Two witnesses, what's required in Colorado. Okay? Unless it's holographic. I already told you about that. What if there's a child born after you write the will? And then you die and you forget to. That's called an omitted child. And the omitted child gets what the other children get. Like if there were two and now there's three, instead of the estate being divided in half, it's divided in thirds. Okay. That makes sense. If there were no other children, that omitted child's still going to take it. It's a good thing. I don't want to spend too much time on the formalities. Just remember, without a witness, it's got to be in your handwriting, not typed up, in your handwriting. Otherwise, two witnesses. You can do the online stuff if you want. Two witnesses. You should talk to your witness. But anyway, okay. There is, I want to say, bad information, bad advertising that's out there. It says, avoid probate because you're going to pay all these taxes and probate is such a pain. And I'm here to tell you, not in Colorado. I already told you about the taxes. So there's a couple of things here. The word probate technically means a judge looking at the will and saying, yep, valid. That's probate. Estate administration is either way, with or without a will. There's an estate that's administered. Most people talk about it all as probate. Well, in Colorado, we have adopted the Uniform Probate Code. And we're one of 18 or 20 states that have adopted. Arizona is also a Uniform Probate Code state. Montana, other neighboring states. What that has done is simplify the estate process. It used to be in Colorado, we had to be very formal about everything. File the estate, you got to show up in front of the judge, you got to ask the judge permission to pay the heat and light bill. Not anymore. Thank God. Okay, so what we can do under Uniform Probate Code, it is not a nightmare. Now, Uniform Probate Code allows what's called informal, unsupervised administration. Informal means you don't have to go to court. You simply file the estate, and instead of the judge, there's a specialized clerk called a registrar, probate registrar. Looks at the will, yep, it's fine, signs the order, you're done. You don't have to go to court. And you don't have to ask permission to pay the heat and light bill. You just do what you have to do. Yes, it takes time. It's going to take a minimum of 6 months. Publish notice to creditors and do stuff like that. But it's not a pain. It's not a nightmare. It really isn't. There's a lot to do. I told you about my friend. He was a hoarder in a way. It was a pain. It was a real pain. But that would have happened whether he had a will or not. Okay? That would have happened. We still had to go through it. So I'm trying to get you to understand it's not a nightmare. It's going to be okay. Write your will. It's important. Leave your things the way you want it left to your children, best friend John, whatever. But leave your property the way you want it to. And the best way to do that is a will. Now in Colorado, we can do something with tangible personal property, chairs, computers, furniture, stuff like that. In your will, you say, I'm going to leave a separate list of what I want done with my tangible personal property. We call that a memorandum disposition. And it leaves your watch, shotgun, great-grandma's hutch, wedding rings, whatever you want to do. It's on that list, okay? Then you want to change that list, you do not have to rewrite your will. Just redo the list. Okay? And that can help a lot. Some of those things are really, I know they're important because they came from your family, they're important, you want to be sure someone's going to get it. Okay? Do the list, it's easy. I did one estate where there were 8 separate lists. But it's easy to do because it's on the list. All right. So we talked about probating the will. Now we're going to talk about administering the estate. Okay. You all have probably heard the term executor. In Colorado, we call that person a personal representative. Same deal. Do exactly the same thing, just a different one. Okay? And you can file an estate no sooner than 5 days after death. Unless there's an emergency and there's a procedure for that. But, so you file the application, okay? Since we had the Uniform Probate Code, which came in about 25 years ago, I have done 1 formal estate. 1. All the rest have been informal, unsupervised.
Oh.
Okay? So it's going to happen for most people and in most situations. Informal, unsupervised is the way. How does that translate to like attorney's fees? Well, the attorney doesn't have to go to court, the attorney doesn't have to do this or that. Yes, there's going to be some fees, but it's going to get your property to go the way you want it to. It's not a nightmare. Please, don't let it bother you. Write your will the way you want it, okay? It's really important. It's important to you. Make sure you write it and it goes the way you want it to. So, 30 days after you file the estate, you have to let the people know, the heirs and the beneficiaries know that you've been appointed personal representative. Simple, notice of appointment. You don't have to go to court, you just sign the paper and send it, mail. Give a notice to creditors. When you give a notice to creditors, they have 4 months to make their claim. 4 months. If you don't do a notice, they have a year. So file the notice. Okay. Daily Cameron will charge you $125 to file the notice in the paper. But they're cut off after 4 months. Okay. If they don't make a claim. Without the notice, they're cut off after a year. File the notice. I'm telling you these things not because I want you to become estate lawyers, so you don't worry about these things. Just be at rest, it'll be okay. So, there's certain things that happen in every estate. It's called an exempt property allowance and a family allowance. So your will leaves everything to your good friend Pete. Spouse says, no, I elect to take against the will, and from the remaining stuff, I get my exempt property. On the little children, they get their family allowance. That comes out first. Okay. And both of these fluctuate on an annual basis with the cost of living adjustment. So what you can see there is there's a total of what, $74,000 that comes out first. So the spouse can get spouse's half plus. Okay? And again, it's so you don't worry about it. So that's an old deed. I just thought it was cool. What year was that? I forget. 1880 something. Oof. Your estate is the property you own at death, unless you have a payable on death on a bank account. That doesn't
Or
count.
on real property? Because you can have that on real property too, on,
Well, on real property, it's called a beneficiary deed.
okay.
Okay, but it works the same way. Husband and wife have a house, they own it in joint tenancy, or they have a bank account, they own it in joint tenancy. That's not estate property on the first death. Okay, because it automatically passes to the surviving joint tenant. Same with the payable on death. It automatically passes to that person. It's outside the estate. Still taxable if you get it up to 12 million, but it's outside the estate. Okay. Life insurance is the same way. Life insurance is payable to a beneficiary. That supersedes the will. Unless the life insurance is payable to the estate. I don't see that very often. Okay. When an estate is done, you have 90 days after date of death to file an inventory. And that's no big deal. Just file it with the court that says, here's the stuff that forms the property.
How detailed does that have to be?
Good question, not very.
Yay.
Unless you have a taxable estate. And
$12
then
million.
you're gonna have to have appraisals and stuff like that. But look, most of us don't have 12 million to worry about. So you list the house,
Contents.
yeah, the Ford, bank account, and the stuff in the house. You don't have to itemize it. If it's significant stuff, the Picasso that's hanging on the wall, yeah, itemize that. But it's not something that you've got to spend a lot of time on.
But if you have your affairs in order, you can almost have that list prepared in your documents.
You sure
can't
can.
you?
You sure can. You leave great-grandma's jewelry to the dog. However you want to do it. And then, while this estate's being administered, the one for my friend is still open. I'm gonna have to file an accounting of what I've done as personal representative. Again, don't worry about it. Think of a checkbook register. That's what the accounting is. I started with this, which was in the bank account, and then I spent this money on that, and I received additional. Here's what I have at the end.
So does the estate have its own bank account, separate from the bank account of the deceased?
I think that's a better idea. Does it have to be that way? No.
Well, it's better documentation, isn't it?
Yes, ma'am. That's why you do it. All right. When you finish this estate, and this is great, you get a receipt. My friend was also a musician as well as a lawyer. And he had a bunch of musical instruments which he left to other musicians. So when I gave this saxophone to one of his friends, I had him sign a little receipt. Said, I got the saxophone that he left me in the will. Easy. Okay. Closing this estate, it's kind of like the front end. It's so much easier now. You don't have to go in front of a judge to get permission to close the estate. You just literally sign a statement that says, I did everything I was supposed to do, I'm done. File it with the court, you're done. Now, what if we have a problem? Now we gotta fight. Who gets the property? Is it the daughter of the first marriage, or the daughter of the second marriage, or what do we do? If we need to have a judicial ruling, we can get in and have a formal closing. We can have a judge look at it and say, here's who gets it if there's a dispute. 90% of the time, there's not a dispute. You just file the closing statement. It's literally 2 pages. Page 1 says I did everything. Page 2 says I mailed it to these people. So it's easy. Okay. I went too fast there. What if, as in my friend's case, he owned property in Colorado and in Arizona? Now what do I do? Arizona happens to be a uniform probate code state, which is good. So I filed an estate in Arizona so we can sell the property in Arizona, but I'm the personal representative. Both places, Colorado and Arizona. Arizona is called ancillary or additional probate, and anything that happens there goes through Colorado. Easy, not a problem. Okay. Taxes, we talked about 12 million. Don't worry about it. And Colorado was really smart. Federal, 12 million exempt. Colorado says we'll do exactly the same as the federal. Okay? No federal tax, no Colorado tax. Now, what about people who say, if I don't have that property in my estate, if I give it away, no taxes? Well, there's an estate tax and a gift tax. Estate tax is 12 million, gift tax is 11 million, and there's an annual exclusion for gift tax. The 12 million's an exemption. The 16,000 a year is per person, per year exclusion. It doesn't count. So if you have 5 children, you can give away 80 grand a year. It doesn't have a thing to do with your gift tax. It's excluded. Okay? Most of us don't do it that way, but with children, you never know. All right. So, should you avoid probate? Well, again, not for all the horrific ads that are out there, but there may be reasons you want to avoid probate. How do you do that? The basic way to do it is don't have much money. Okay? Colorado says if your total assets, not counting real estate, your total assets, cars, chairs, stuff, less than $74,000, you can do what's called a small estate affidavit. Done that lots. Your surviving children say, well, Dad only had 50 grand in the bank and the car isn't worth anything. You sign an affidavit that says, we are his children and we get it all. You give it to the bank has to honor it. You don't have to file any estate or anything. You just have this small amount, you file the affidavit, you prepare the affidavit, give it to the bank. Okay? Same with the car. File it with Department of Motor Vehicles. It's easy. Most of us don't want to spend it down, but you can't do a small estate affidavit with real estate.
Oh,
Has to be stuff. But with real estate, you could do joint tenancy. Okay?
Excuse me, does the small estate affidavit include a small bank account, or is it just
Yes.
personal property?
It includes the bank account. That's because a bank is personal property.
Or an investment account?
Personal
Stocks
property.
and bonds and stuff?
Yeah. Okay. And on your stocks and bonds, just like on your bank accounts, you can have a payable on debt. And if you really want to keep it out of probate, that's the way to do it. Do your payable on debt. Okay. And I often see that. And it's a good combination for people is, well, I might do a payable on death for this, this, and this, but the rest of the stuff I want to go equally between the two. However you want to. Same with your insurance, your life insurance. You can have different beneficiaries or however you want to do it, because life insurance doesn't count in your state. Give away your money. Yeah, you could do it.
I used to tell my mom I wanted her last check to bounce.
It happens. I get it. Okay, so what else should you do? I mean, I've talked about wills and estates. It's not a nightmare, you can do it. The important thing is being sure it goes the way you want it to go. So you write it down. You also talk to your children.
So what happens if you're aging solo? You don't have children, you don't have a spouse, you don't have siblings, you've got no family. How does that work? How many different considerations are there?
Oh, there's a ton of considerations. Where do you want to leave your estate? No children, no relatives, you're the last in your family. Your church, American Cancer Society, Boulder County for their open space program, whatever you want to do, you can do. The real problem you have is on the next slide. You know, what I've talked about estates and stuff, that's after you die. But what happens between now and then when you're not competent? Then you need powers of attorney. We'll talk about this. Remember, your will has no legal standing until you die. Powers of attorney are the opposite. They're valid now, and when you die, they die. Okay? So most of us, statistically, are going to have situations where we're not competent and we need help. So first thing you need to think of is an advance directive. It's called a living will. Colorado's technical name is Declaration as to Medical Surgical Treatment. Living will. That one says, look, if I'm terminal, don't keep me on the machines. Or even don't plug me in. And you can modify that any way you want. Wait 7 days. Have 2 physicians tell me, however you want, but it's valid. The doctors, the hospital have to go on. Okay. You can also have in there anatomical donations. You could also do that on your driver's license. You could do that on a separate written document. And you can limit anatomical donations to just parts of my body. Think of your corneas on your eyes. My father-in-law died of cancer and there was no way anything could be used except his corneas. Could use it. There's another thing you can do with your body after you die, which is leave it for medical education. Translation, a cadaver medical students to study.
So that would save cremation costs.
Yes, because the medical institution that receives your body also agrees to dispose of things properly. So it's tough, and it's a thing that people don't want to talk about necessarily. Please, if it's important to you, talk to your children. Talk to them now. I even tell my 40 and unders clients, talk to your children when they're able to understand what you're saying. This is what I want. Okay. Talk to your children.
You can also donate your body to a body farm
Yes.
for forensic use.
Yes.
And there's one in Colorado.
You're kidding.
No, I'm not kidding.
That's
There's all things you can do,
amazing.
for sure. Okay. You all have probably heard of things like do not resuscitate, or a CPR, cardiopulmonary resuscitation. Lawyers can't write those. Doctors have to write them. My mom had CPOD, and she had a DNR. So if she's going, don't resuscitate. Those are valid. But you also want to be sure the person who has that should carry that document with them. And you can even get like a bracelet or a necklace that says, don't resuscitate. What I want you to understand is you have to do that with your doctor. With a living will, you can do that part of it, and powers of attorney you can do with your lawyers. But these others, you've got to do with your doctor.
What's the standing of dementia directives in Colorado?
I'm not sure what you mean by that, but I would take that as a medical power of attorney, just like that.
Like a living will, but if I have dementia, this
It's valid.
person is,
It's valid.
it's valid, okay.
Yeah. 2 witnesses. You've got to do it with the witnesses in those.
There's a new state app that goes on your phone or something like that, that allows you to put driver's license, vaccine cards. Can you put these kind of documents in there also?
You can. But here's what you do. When you sign your medical power of attorney, take a copy with you next time you go see your doctor. And ask your doctor to take a copy, put it in your medical record. You travel, go visit your kids in San Diego, New York, wherever, take a copy with you. Because Colorado medical directive is valid in New York or California. And the reverse is true in an emergency situation like that. If you move, then I think you need to change it. Because the hospital says, no, wait a minute, this is a Colorado medical power of attorney, and they now live in California. No, we want a California. Okay. But if it's an emergency, most will do it.
Medical power, is that the same thing as the living will? Or is that, are you talking about
Two
a
different things.
DNR?
A medical power of attorney.
Mm-hmm.
There's 2 powers of attorney. One's medical, one's financial, sometimes called general. The medical power of attorney gives to another person the right to make those medical decisions for you. I'm no longer competent. I'm in the hospital and they got to take my leg. I can't say yes or no, but my daughter can. She's got my medical power of attorney. The doc talks to her and says, what do you think? She says, take it off. That's a medical power of attorney. Now, if you haven't written one, but you're in the hospital, they can do it with agreement from your children or your spouse. You could do it ahead of time with something called a MOST, Again, lawyers can't write it most. Doctors can. If it's really important to you, tell your doctor and they'll write it up. This is treatment that they want. No, they don't want cardiopulmonary resuscitation. Or no, the lungs are so bad we're not going to have a lung transplant. That becomes a part of your medical record. That's why only doctors can do it.
Do you recommend that people put this on their refrigerator in case first responders come into the house to take you away?
Yes, yes.
You do, okay.
I think it's that important. I said I have a disabled daughter. We didn't put it on the fridge. There's a file with that stuff right by the door. Okay. So that first responders, when they come in, they see, and it's marked. First
File for
responder.
Life is the program, right? File for Life is the program
Yes.
in many states.
Card,
Yeah.
file for life.
Yeah. You can get a card.
So on the CPR do not revive order, that means that people would not provide basic life-saving on you if you, like, say you were drowning or
Yep.
either of those. Why would somebody choose that if there was a possibility they could, live years longer afterwards?
Let's go back to the idea of a living will, okay? Because I think that's the answer. In a living will, you can say, yeah, don't keep me alive artificially. If I'm terminal, don't keep me alive. But in the meantime, administer medication that's necessary for pain management, nutrition or hydration that's necessary. Yes, we can do that. It's just if I'm terminal. And you can define that. The best way is to say, two physicians, one treating and another one, say, you're done. It's true. You're in a coma and you're not likely to survive. The history of medical powers of attorney dealt with a lady named Cruzan and went to the Supreme Court. And this poor woman had been in an auto accident and she had some of those directives. And the question was, do you have to follow? The answer is yes. So if it's important to you, please have a living will. And you can specify what you want. You have, if I'm terminal after 30 days, then maybe pull the plug. Or 7 days, or whatever you want. And in the meantime, feed me, keep me on pain meds. You can do that. That's the living will, okay? The do not resuscitate are separate orders that say, don't resuscitate me. Okay. And again, the docs have to write that. Carry it with you.
Also, hospitals require you to rescind that if you have surgery. Rescind it during the time of surgery and some period after it, which is a major concern for many of my friends.
Yes. Maybe one a different hospital.
Duh. Well, it's about legal issues.
Yeah, I understand. And hospitals have their own lawyers.
Yep.
Okay, so we're talking about powers of attorney. Remember, there's two kinds, general or financial, and medical. So again, a situation where you're the last in the family, you have no children, no brothers and sisters. Who do I name? It's tough. It's tough.
It's hard to find anybody you can hire.
Right. Well, that's one way to do it. Remember that a general power of attorney will do you no good in the hospital, nor will a medical power of attorney do you any good with the bank account. you need to. There are professionals who act as powers of attorney. They will charge you, okay? But you can get it done. People often name friends, people they've known. You know, you went to high school with this guy. It's now 60 years later. Sure, you could do that. Problem, when you name somebody that's about your same age, what if they go first? What if their Alzheimer's kicks in before yours does? It's a tough, tough choice. But you could have your high school buddy first and maybe a professional second.
Well, and can't people decline?
Yes.
Being your power of attorney, even if you,
Yes. Yes. So talk to him first, okay? Because you don't want to write a power of attorney and then they don't want to do it. Okay?
Can you write something that would say, this is my power of attorney, but if they can't or won't do it, then this was my power of attorney?
Yes. Sort of successors, kind of like you can do in your will for your executor. First choice is my spouse. Second choice is my older child. Third choice is my best friend, Bill.
And you could have like our choice, like the last resort is such and such law firm or something.
Yes. Better choice is the public administrator. In
Really?
Colorado, we have public administrators. We have a public administrator in Boulder County. And those are lawyers, but they are specifically named when there's no one else, okay? Or they themselves are named. I recently did a will for a person who was the last in their family. They named 2 friends, and if those aren't there, then the public administrator. That's fine. That's fine.
Is there like a official name for that, like the public administrator of Boulder County or something?
That's it.
Okay.
and it has to be specified?
No.
Or if there's no, if nobody else takes it, that's the default?
That's the default.
Okay.
Right.
And they charge for this,
Yes, they do, but it's fixed rate
minimal.
and it's down here other than what
Okay.
lawyers would normally charge.
But they just charge it to your state, or is it?
Yes,
So you don't have to prepay it?
no,
Okay.
Well, wait a minute, this is powers of attorney, this is why you're alive.
yes,
So it isn't charged to your estate, it's charged to your, I mean,
it's charged to you,
You.
your estate.
Right.
Right. And if you're not competent, then who pays the bill?
right, he's got,
And if you have none of that, then we're gonna have to have a guardianship. A guardianship is a formal proceeding in front of a judge, and it's tough, let me tell you. You wanna take in grandma who's now not competent, you're gonna have her show up in court and testify? It's difficult. Court system has what's called visitors. So a trained person goes out to where grandma lives, interviews, and then reports back to the court, gives them a snapshot. Says, Judge, this lady needs a guardian. So you, the daughter or son, go into court and say, here's the visitor's report, here's the letter from grandma's doc, and the judge says, got it, you're appointed guardian. Guardian is for the person, conservator is for the property. If there's no conservator, guardian can do both. But that is a definite court proceeding. You've got to go to court. It will cost more and it's much more difficult. During COVID, oh gosh,
oh,
really tough. Folks who didn't have powers of attorney, but you do what you can. Whatever the power of attorney is, you want it durable. You've probably heard that term, durable power of attorney. Durable just means if when I sign the power of attorney I'm competent, but now I'm not, it's still valid. It used to be the other way around. Crazy lawyers. It used to be, you had to be competent when the power of attorney took effect. Wait a minute, how do we do that? No, they've got it right now. It's durable. You're competent when you sign it. It survives your incompetence. It does what it's supposed to do. Okay. Colorado has state preferred forms for both of these. Okay. When you go into the hospital, they're going to ask you, do you have a medical power of attorney? If not, you can sign this one. Do you have a living will? If not, you can sign this one. Okay. The question would be your competence. It's okay to sign the ones that the hospital do if you don't have one. Much preferred. Talk to your lawyer now and get it done. It's not going to cost you an arm and a leg, really. It's not. Okay, how are we doing? Oh, this is the last talk, but a real problem with the power of attorney is that effective now. So that person with your financial power of attorney can clean your bank account out and go to Acapulco. And I'm not kidding, it happens every once in a while. So you got to choose that person wisely. Also, you can make this power of attorney immediate, takes effect as soon as you sign it, or it only takes effect when you're incompetent. And it then springs into effect, if you will. Question, how do we determine you're incompetent? Write in the document that it takes a letter from your doctor. That defines incompetent. Because otherwise, you could wind up in court again, trying to decide who's competent or incompetent. What was the lady singer's name? Britney Spears. Okay? No, you don't want that. You don't want that. So write it now. Okay. You don't want to become a test case, for sure. So, other things to think about. One is a burial plan. It's a very good thing to have. Things are emotional, tough on death, but if you have prepaid burial plans, sometimes that helps a lot. Required? No. It's okay. Not required, but you could do it that way. Proxy decision maker. Remember I said, if you don't have a power of attorney, there's still a way to do it when you're in the hospital? That's it. It's called a proxy decision maker. Your doc says you're not able to make decisions now, but you don't have a power of attorney. But I know you've got your daughter Mary and your son Joe. We'll call in Mary and Joe and say, what do you guys want to do? And Joe says, Mary, why don't you do it? Mary says, okay. Mary is then signed up in the medical record as the proxy decision maker. Please don't wait for that. It's there in case you didn't get it done. Do it now, but if you don't, there's a way to do it. Okay? And there's another part of it. How about for Medicaid or other medical benefits? You can have a surrogate decision maker. Again, it's Mary or Joe, or even the grandchildren, or even good friends. But that can be done. It can even be a doctor. Not your doctor, but another doctor at the hospital that's approved by the hospital ethics committee. So, it can be done. Again, don't wait for it. Do it now. Somebody asked Well, not somebody. I get these questions all the time. Well, can't I do it myself? Can't I save more money? Yeah, you can. You can. But if you've got a $500,000 stake or $1 million stake, think about it. Spend $1,000 or $2,000 maybe. Powers of attorney and your will, get it done. Protect it. Okay? All right. What's this disposition of last remains? What it means. That's your body. There is a form you can do that writes up, says, here's what I want to do. You can do that. You can also say that in your will. I want a funeral service, and I want Amazing Grace to be sung, and I want whatever. You can do that. Okay. Binding. So if it's important to you, do it. Okay, write it out. Wow, I think that's it. Yeah. Any more questions?
What's the difference between a will and a trust, and the advantages and disadvantages?
Okay, that's a big question. A will takes effect on your death. A trust can take effect now. And you transfer property into the trust. Okay? And the property that's in the trust is administered by trustees. Could be you, could be someone else.
So you can make it so that as of your death,
Here's how my property
then
goes.
somebody else
Yeah.
administers it other than yourself.
You can have a trust that says, I'm the trustee, but on my death, all the property goes to, same as in your will. Okay. Is that probate property? No. It's in the trust. So it's a way to avoid probate. There are lots of other reasons. I mentioned I have a disabled daughter. We have a trust for her. You could do a trust now if you have some complex financial things and you want to do things differently. It's possible. I am not a believer in writing trusts just because they're neat.
Thank
Nifty.
you.
I think they cost more money and can be more difficult, and in the long run, it costs more money because you gotta file separate tax returns and stuff like that. There are good reasons, okay?
Like $12 million, would that be a reason?
That's a reason. You bet.
Yeah, I don't
Property
know that.
in different states, different countries. Yes, that's a reason. Okay. And I see people who wind up on purpose. Stuff in trust, other stuff not in trust. You want to put your house in trust now so that the trust owns it, not you? Well, I'm the trustee. Yeah, okay, but we got problems now. What if you're incompetent? You can't act as trustee. What are we going to do? Got your POAs there? Okay, I hope, but. So there are complications. They're different animals. And a trust is kind of beyond our discussion topic here. They're different animals. Effective. Both are effective. Most of us just need this will. Okay. Yes, sir.
You talked about federal gift tax, and I think you said something like $16,000 per child per year. Can the parents give that to the spouse also?
Yes.
So it's up to $32,000
Yes.
per year.
So a spouse, that's exactly right. Good question. So husband and wife decide they want to give $16,000 to their grandchildren. The two of them together can give 32 to each grandchild.
And to a son-in-law?
Yep. You
Okay,
could do that too. Yep.
thank you.
Who keeps track of the amount of money you've passed on to these people? I mean, what happens if I give them $100,000 each?
It's your obligation when you give them $100,000 to file a gift tax return. You won't owe any tax on it because you have an 11 million exemption.
So it always goes to the big exemption, to let a million, relevant to that.
Yeah. Yeah. Yes, sir.
So if you receive money from a friend over the 16,000, do you have to declare it with taxes?
No. Not your problem. It's not the recipient's problem. It's the donor's
Who keeps track?
problem. Donors. I mean, most of that stuff doesn't get discovered.
So I don't have-
Big
I don't have
amounts.
to worry
Well,
about
unless you
it.
got the Medicaid thing happening.
That's where it's gonna show up. Your application for Medicaid. Have you given any money away in the last 5 years? And if you say no, and you did, you're out of luck with Medicaid. If you say, yes, I did, Medicaid's gonna say, oh, 5-year look back. You're not eligible yet.
But the $16,000 isn't a problem,
It is for Medicaid,
okay,
but it's not for gift tax.
right,
Okay?
okay.
So you give away 16 grand to your child, and then you apply for Medicaid, that 16 grand's gonna get called back
For 5 years.
for 5 years. So if you're gonna stay healthy, you set a trust now, put that money in a trust, and give it away. Give it away. You can't be trustee, give it away. If you live 5 years, that trust doesn't count for Medicaid.
Or start early.
Yes, ma'am.
Start
Start early.
dispersing early.
And don't die for 5 years. So it's difficult, but think about it this way. The federal government spends over 50% of all the money it spends on Medicare, Medicaid, and Social Security. So the rules are complicated, and they pay attention. And thank God they do. Like I say, my daughter's disabled. I'm really glad that the government's there. I can't pay for it. So they help. So, okay. Any other questions? Yes, sir.
What's the minimum that you could give somebody and still qualify without a penalty for Medicaid later? 0?
Wow. Or do it in cash, which is not traceable as, it's
Not
not like it's in
traceable,
your
but-
bank account.
But you sign a document that says I didn't.
Ah,
And if you sign it that says I didn't, but you did, they can throw you out.
If they
Believe me,
can
there
figure
are
it out.
ways to figure it out. So be truthful, don't plan ahead of time. It's okay. And if you still have some money in the bank when you have to go into nursing home, it's okay. Spend it down. Then you can go in.
So if my stepdaughter is listed as the beneficiary on my husband's assets, like his 401ks and things like that, and you're saying that as a spouse, I'm allowed to have? I am not if she's listed as the beneficiary?
Correct.
Okay.
You're allowed half the estate, and the bank account that has a POD is not part of the estate.
Okay, so anything, POD with her name, beneficiary, any of that, that is definitely hers and not something that I can go after.
Yes, ma'am. Had that issue come up in court.
Not that I'm gonna do that, but
always good to know.
yeah, I just wondered, since you said that you're entitled to have
But that's only the estate,
only the estate.
only the estate. And remember, POD, joint tenancy stuff is not part of the
For
estate.
trusts,
Okay.
trusts aren't included in there, are they?
That's correct.
Thank
Right? Yeah, it's complicated, I know.
I was gonna ask if I have a daughter that lives in India and I die, what happens, in that situation?
And if your daughter's your beneficiary in your will,
She's half of my beneficiary, yes.
it's still hers, even though she's in India. I had an issue with that on an estate, and some of the people were in Nepal.
Same.
Same thing. You have to be very careful how you get that money there, so that they get it. Okay? But it's still theirs.
It's possible.
It's their property. Yeah, it's possible to do. Yeah.
But it can be complicated.
Depends on the law of where they are.
Okay.
Most countries have treaties with each other that are supposed to make it easy. But yes, the daughter in India still owns that. Maybe some problem, technical problem getting it to
But
her.
she doesn't have to fly back to Colorado to get it? Maybe?
I want to say no. 95% of the time, no.
Okay.
The people in Nepal in this estate that I was doing, there was I want to say it was a back channel. There was nothing illegal about it. It was very straightforward, but it was a different way to get it done. It was done. The people in Nepal did not have to come. They got it.
Oh, that's good.
All right. Good. Then we're done.